Goldman, a Democrat from New York and a former federal prosecutor, brought the heat, but not in a partisan way. His questioning exposed a deeper issue. What happens when members of the executive branch start acting as judge and jury? Goldman's point was clear. The Constitution gives the judicial branch, not the executive, the authority to interpret laws and decide guilt or innocence. That's basic civics, something every official, especially those wielding power, should know and respect.
What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What steps have you taken? Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is? The judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that notwithstanding your statements under oath here today that Mr. Kilmar Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this indivial.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence... So you're not going to commit to follow this order? You won't commit to follow this court order?
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering. Stop filibustering.
By gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately.
So
and he is not.
How can you say he's been treated appropriately if the Supreme Court has ruled 9-0 that he hasn't been treated appropriately? Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
no.
investigators and law
that is
enforcement
you
officers
making that
in the case they
determination.
built against him. If you don't
the
trust our law
court
enforcement
has considered all that. The judge has considered all that, Madam Secretary. And if you would be quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What steps have you taken?
If your continued advocacy for him were to...
I'm not advocating for him.
Yes, you
I'm
are.
advocating for a
Absolutely.
court order, Madam
Gone to the
Secretary.
mat for this
The
man
court
who
order
has terrorized
says
people
that
in
you
traffic
must take
and human
steps
beings.
to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution.
Gentleman's
and you
time
should
has
fight too for due
expired.
process.
The gentleman's time has expired. I now...
What you just watched wasn't a spat over procedure. It was a rehearsal of a much larger question about what kind of country we are willing to be. The exchange between the Congressman and Secretary Noem about the Kilmar Abrego Garcia case pulled aside the curtain on two competing impulses: the urge to act decisively against real threats and the equally essential constitutional obligation to give everyone, even the accused and reviled, the process the law guarantees. The Congressman's line of questioning kept returning to a simple, consequential truth. In our constitutional order, judges interpret the law and courts enforce the protections the Constitution provides. That isn't academic hair-splitting. It's the mechanism that prevents politics from becoming law and prevents raw power from substituting for justice. When the Supreme Court speaks unanimously, 9-0, and says someone was denied due process, that's not a polite suggestion. It's a directive that the executive branch must respect and act on. To shrug at that, or to treat it as optional, is to chip away at the separation of powers that keeps our liberties secure. Listen to what the Congressman was doing. He wasn't defending a gang member. He was defending a principle. He quoted a conservative appellate judge who said, even if the government's allegations are true, the individuals still had to be afforded the legal process to test those allegations. That's the point the founders wired into our system. Guilt must be proven in a court of law, not declared by administration decree. If we start letting the executive prune people from the roster of legal protections because they're unpopular or scary, we've traded the rule of law for something much cruder. Secretary Noem's responses revealed the tension in practice. She pointed to law enforcement findings and framed the matter as one of public safety, a narrative that lands emotionally because no one wants violent actors on the streets. But the question the Congressman kept insisting on was narrower and more painful. What steps did the administration take to comply with the court's order? Did you bring the case back before a judge? Did you follow the active steps the court said were required to restore the process that was denied? The answer can't be trust us or we treated him appropriately when the Supreme Court, an independent judiciary, has already said due process was not afforded. This is not a legal hair-splitting exercise for lawyers alone. There are real consequences. When courts are bypassed, decisions that should be subject to adversarial testing become unilateral declarations. Evidence that would be tested under oath, cross-examination, and public scrutiny never sees the light of day. Witness credibility isn't examined. Discrepancies aren't reconciled. The public never gets to observe whether the government's case would survive the rigors of legal challenge. That's how miscarriages of justice happen, and it is precisely that risk the Congressman was trying to guard against. There's another dimension here that's worth parsing: accountability and precedent. The Congressman's frustration at Noem's refusal to commit to following the court's order wasn't rhetorical, it was a warning. If an administration can simply ignore a judicial finding because it dislikes the outcome or because the accused is loathsome, what stops the next administration from doing the same, to people less sympathetic? Today, it's a suspect tied to a gang. Tomorrow, it could be a dissident, a minority leader, or any citizen who opposes those in power. When exceptions become normalized, the protections meant to be universal become selective. The moral clarity of insisting on process is also practical. When the government is confident in its evidence, as the Congressman pointed out the administration claimed to be, then the right answer is to let that evidence be tested in court. If the evidence is strong, it will prevail. If it isn't, then democracy and justice are served by the truth. The confidence to face judicial scrutiny is the mark of legitimate authority, not weakness. So what should a viewer take away from this besides the drama of the moment? First, democracy is not a spectator sport. When elected leaders treat court rulings as optional, they rely on the public's passivity. Second, defending due process is not defending criminals. It is defending the constitutional architecture that protects every citizen, including you and your family. Third, oversight matters, not because members of Congress want to grandstand, but because their job is to ensure that the executive obeys the law and honors the judiciary's role. If you believe the rule of law must mean something, even in the hardest cases, don't let this moment pass. Contact your representatives and ask them to defend judicial authority and the procedural safeguards that keep power in check. Read the Supreme Court's opinion for yourself. Urge leaders to comply fully with court-mandated remedies. Insist that the government bring disputed facts before a judge where they can be examined transparently. This was more than a tense hearing clip. It was a civic alarm bell. If we let court orders lapse into optional suggestions, especially when a unanimous Supreme Court has spoken, we risk trading the predictable, flawed, but fair procedures of our justice system for the unpredictable rule of men. That erosion is slow, but it is cumulative, and it always starts with a moment like the one we just saw. If you care about preserving constitutional protections and ensuring that the promise of due process applies to everyone, share this video, subscribe for more coverage that holds power to account, and join the conversation. Democracy depends on citizens who refuse to look away.